Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Craig Robinson. Craig is a partner at Robinson & Casey PLLC, a Florida law firm that focuses on behavioral health, including the Marchman Act and mental health guardianships. He regularly works with families who are trying to understand the legal steps involved in accessing treatment for a loved one struggling with addiction. I'm Lisa Mosby, and today we're focusing on who is legally allowed to file a Marchman Act petition in Florida and how that process begins. Craig, are you ready for today?
I am ready, Lisa. Let's do it.
Once families learn that the Marchman Act exists, one of the first questions they ask is whether they personally have the authority to start the process. So, can you tell us who is legally allowed to file a Marchman Act petition in Florida?
Great question. Lisa, any adult with personal knowledge of an individual's substance use and the behaviors that are associated with their substance use can file a Marchman Act. It does not have to be family. This is a common misconception, actually, that we often get. There was a period of time in Florida law where if an individual was not a family member, that you needed 3 individuals to actually sign the petition, but that is no longer the case and changed in 2017. Now it can be any single individual who has knowledge of that individual's substance use and behaviors associated with it. It also can be co-petitioners, so it does not have to be one. So if there is a family member who doesn't want to take on this burden and this task by themselves, we can certainly have co-petitioners in a case. I also will just mention that oftentimes we will selectively choose who the petitioner is in an attempt to insulate a particular individual from the legal case itself. An example of that would be spouses. This comes up pretty commonly, where we have spouses who may be on the brink of divorce, let's just say, and the spouse that's non-addicted is calling us but wants to file a Marchman Act, but wants to do so in a way that their husband or their wife may never find out about it. That unfortunately is impossible. They will ultimately know that it's been filed and they will know who filed it. So in that particular circumstance, we may look to other family members, parents, brothers and sisters, or even a non-family member, a friend, to be the petitioner in the case so as to insulate the person who wants to kind of, protect themselves and protect maybe a relationship a little bit more from the scenario. But we commonly have cases here where we have friends, we've even had business partners that have filed the Marchman Act. That may sound a little bit strange to some people, but as Richard Casey and I commonly say to each other, since we're both in recovery, that if one of us, God forbid, relapsed and needed to be in treatment and we were refusing treatment, we have come to an agreement between the two of us that we would Marchman Act each other if necessary to protect each other from addiction. So that does happen, but most of the time it's family. The most common case we have are parents of adult children who are using this law.
Craig, we've been talking about this for some time now, and the thing that keeps flashing in my head is, does a healthcare professional have an obligation to perhaps use the Marchman Act? Maybe, I know in cases where we observe children being abused, I work with a lot of kids. I have an obligation to make sure that that child's protected and to turn in that situation and make sure that it's investigated. Is that the case with the Marchman Act? Is there an obligation at all by someone who is in a profession that can help someone? Are they obligated to get them help?
That is a great question as well. All your questions are great, Lisa, by the way. I think I say that on every question. It's a great question because the answer to it really is that it could be an obligation. And what I mean by that is that this is actually kind of a more groundbreaking issue in Florida. This year I believe it was it was last year, April of 2025, there was a case involving a wrongful death in Florida where there was an individual in a facility who was under a Marchman Act, and that individual left the facility, and the behavioral health professionals at the facility did not take enough steps to make sure that that individual was safe. And the reason why that case is important is that it was the first time in Florida law that the Marchman Act was used as a basis for liability in a wrongful death or a personal injury claim. And I think that there could be more of that coming down the pipeline. And there's nothing saying that in Florida law that a clinical professional or a medical professional has to utilize the Marchman Act when they see fit that someone meets certain criteria. But I have to also tell you, I'm a recovering personal injury attorney myself. And as a recovering personal injury attorney, if I had a situation where a family came to me and they had lost a loved one, let's just say, that was in a facility or that who had interacted with a behavioral health professional or a medical professional, and they likely met criteria, but that professional did not utilize the Marchman Act or the Baker Act or their ability under the law, or even recommend it or even consider it, I would likely take that case and pursue the individual who didn't utilize that to protect that person. And so to answer your question, very well, the person could be, I think, obligated. I think that all therapists and medical professionals should know about this law, at least to an extent of knowing what the criteria are, and therefore knowing how to spot a case where it may be appropriate.
And Craig, we started off talking about the family's situation and how we might want to protect a spouse. But when someone files a Marchman Act petition, what does the court expect the person to actually know or be able to explain about the situation?
So when a person files a Marchman Act, the first thing that is done is they have to submit an affidavit. And that affidavit usually contains the information that they have that substantiates the need for the Marchman Act petition. When we draft it, we oftentimes include a very detailed timeline of how we got here, right? It's kind of our initial phase in our firm where we're fact finding, where we're asking the client, the family, a lot of questions about what behaviors are present. Is the person aggressive? Have they overdosed? Are they driving while intoxicated? Are they disappearing, which happens to be a common one, for long extended periods of time? Are they neglecting medical conditions because they're self-medicating with a drug or another substance? Are they in psychosis? Are they taking an unsafe amount of a drug, or are they drinking an unsafe amount to the point that their health may be deteriorating? All of these questions are questions that we would be asking the family and that we would be included in the petition. One of the things that I do have to mention that does come up from time to time is, oftentimes when someone's using drugs, they do it discreetly, right? They're not necessarily doing it out in the open. And so the family may not have actually seen the person using drugs in certain circumstances. But let's just say that they know from their loved one's history that they're acting in a manner that is consistent with their prior use of drugs, which is most often the case. Then in that petition, we can oftentimes allege things like, here are the behaviors that we have. Here's what the person is doing. Here's why we feel like it's unsafe. And upon information and belief, kind of a legal term that we believe based on this person's actions, that they are abusing drugs or alcohol, that is usually enough for at least for us to get that initial assessment, as I talked about in the last episode. And then on that assessment, they're going to be drug tested. They're going to be tested to determine if they have alcohol in their bloodstream. And I have to tell you, most often is the case when the family suspects that there's drug use going on, usually, like way more often than not, when they get to that assessment, they test positive for substances, and we kind of get a better picture of what's actually going on. But, families will ask us, do I need medical records? Do I need other records? Do I need documents? Do I need police reports? Do I need all these things? Most of the time, families don't have access to that information, or they may not, there may be no police reports. And if there's medical records, they may not be privy to them. We generally don't need it. In order to start the process, usually that affidavit from the family, a sworn affidavit stating what the facts are that have led us to this point, is sufficient to substantiate the case.
And then, Craig, once a petition is filed, what role does the person who filed it typically play during the court process?
Once the petition is filed, the only real involvement that that person may have going forward is to appear at any subsequent hearings and potentially to offer testimony, which is consistent with what they stated in that initial affidavit. This would only be necessary if their loved one contests the Marchman Act process. If it is uncontested, then that testimony would likely not be needed. That may sound a little strange as well. Like, what do you mean not contested? Normally, most often in our cases, once the person has been evaluated and once they appear in court and once they know that the results of that evaluation and all of the history is about to be told in a courtroom, most of our cases at that point resolve by agreement, because the person who is being Marchman Acted does not want to go through that kind of a process where their family is going to testify, the therapist is going to testify as to everything that's been happening with them and what drugs they tested positive for. So the family could have to testify at hearings, but most of our cases are resolved by agreement without the need for that. The one other thing I'll mention, Lisa, is, and I think you're going to cover it probably in a future question, possibly, but we want to make sure that the petitioner in the case is someone who can hold their ground. What I mean by that is that if their loved one is under a court order to be in treatment involuntarily, and let's just say they fail to comply with the court order, we need the family to tell us to take action to enforce the order, to go back to court, to get the judge to potentially impose a consequence or to force compliance with the court order. So we want to be really careful. One of the things that we tell our families on the front end is, unless you're willing to go the whole length of this and really make sure that if your loved one tries to open a door, that you are, that you have enough courage really to close that door, instruct us to close that door. Make sure that you're willing to do what's necessary in order to really fully enforce the process if need be.
And it's not just what is asked of them and what's necessary, but oftentimes I'm guessing there's some misunderstandings that people have about filing a Marchman Act petition. How do you find yourself correcting those early on so they can meet those expectations?
Yeah, it's just, we have a pretty lengthy consultation process, where the families can ask those questions, and we really cover a lot of that in our firm so that they know, everything to kind of expect in, during the case. I'd say the thing that comes up most frequently for families in that circumstance is, number one, they want to know that it's confidential, right? Which it is. So the moment that it is filed, it is sealed from public record. So you or I would not be able to go on the court docket and find Marchman Act cases that other people have filed. It's not public record, and nobody else really has, the privity to actually find those records. So it is a confidential process. But that's the other thing, though, that people want to know is, am I going to have to go to court? Am I going to have to face my loved one in court? And really the answer to that question is yes. Now, I will just also mention one other thing. Usually it's not just one family member that feels that the individual needs to be in court. So we may file the case with one petitioner. What I oftentimes recommend to families, though, is that other family members appear at the hearing, and they appear in support of the individual getting the help that they need. Really, that the family be a united front. To the degree and the extent that it's possible, don't have one person take on this burden alone. Even if one person is the petitioner, it's helpful to have other family involvement. And if the family is united in that mission to get their loved one the help that they need, it creates a much stronger situation where I think for the person undergoing treatment, they can really look at that screen or that courtroom and see, wow, my entire family feels this way. And it could be a really powerful moment oftentimes.
Craig, there are some expectations of what a family will go through to file for a Marchman Act. There's also misunderstandings. We kind of covered some of them, but I think the last one, and here's where I want to close this up, is if people are fearful. You mentioned that privacy goes into play right away, but if we're fearful that this could hurt their future employment or hurt their current employment, or we have fears about moving forward with this, can you give some words of assurance to folks that just having the conversation with you is the first step, and maybe that will help to alleviate some of those fears?
Absolutely. That is a question that comes up pretty often too, is what kind of impact is this going to have on my loved one going forward? Are they going to be able to get a job? Is this the kind of thing that appears on a standard employment background screening? And the answer to those questions is no. It will not appear on any kind of a background screening for standard employment. It will generally not be something in our experience that is even asked by an employer. We have many, many people who have gone on to be very, very productive employees. Even one that comes to mind too, that's an entrepreneur that started his own business after being Marchman Acted. People that are in active addiction are oftentimes highly intelligent and highly capable people. It's just that the addiction is holding them back. So the great thing about this process is it really has no impact going forward on someone's ability to live a long, productive lifestyle. The only caveat to that I'll mention is that it does restrict gun rights in the state of Florida. So when someone is Marchman Acted, they lose their privileges to own a firearm, carry a firearm, and that will remain in effect until that is discharged. So even when the Marchman Act is over, they still cannot own a firearm in the state of Florida until they come back to court and file paperwork to have those privileges restored. Now, I will just also say some families, that's actually, believe it or not, a hang up for some families. We've had some families say, oh, I can never take their guns away. And I'm thinking to myself, they probably shouldn't have a gun to begin with. Under these circumstances, but that is a hang up for some of our families, but it is something that can be discharged. But as far as other impacts, there really aren't any that this would have on someone going forward.
And I think we'll leave it there for today. Thank you so much for your insights. Folks, that's it for today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Craig Robinson and the work of Robinson and Casey, PLLC, including resources about the Marchman Act and mental health guardianships in Florida, visit robinsoncasey.com. Thank you so much for listening, and please leave a review and subscribe to the show so you don't miss the next episode. We'll see you there.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.